a lack of success on our part. I'm picking up on a question which I either understood properly or didn't understand or was interrupted by Siri, but you asked me, is it necessary to set aside the answering affidavit? Not entirely. It remains filed and can be referred to by everyone in the fullness of time. But it can't stand as the substantive answer to our founding. That's all we're saying. If it stands as a preliminary answer which will be supplemented as an answer once we have supplemented our founding papers with a response to the record of decision and the reasons, and possibly amended the notice of motion, because things can change once we know what documents were relied on and what the reasons for the decision are. And then they can supplement the present answering affidavit. But strictly speaking, you should set aside the answering affidavit because it's filed prematurely. But if or ordering, rather, the record of decision and the reasons to be provided, well, you're the master of your court, and that could be possible. But that does not mean that we would not have been successful in this stage of the application, and that does not mean that costs would not follow. That's the heart and essence of our argument, and we would commend the two judgments, the Bada judgment, where Judge of Appeal Nafsa quotes from Bada on piecemeal litigation, and in particular the judgment of His Lordship Judge of Appeal Brandt in the Competition Commission, and to say, at the very least on a procedural level, they cannot avoid the mechanism of Rule 53 by deciding in advance that we have not made out a prima facie review, and therefore they will choose to ignore the rule that we rely on. Beyond that, of course, it's clear that this is administrative action and reviewable under the principle of legality. But it is perhaps not necessary for you to go that far in your judgment in order to reach the decision that they've got to comply with the rule.
There's in fact very little dispute between the two sides here with respect to how Rule 53 operates, how administrative action can be reviewed by the courts, whether under PAJA or under the principle of legality. The dispute here is that what my learned friends seek is a legal impossibility because there is no decision here. And I listened very carefully to my learned friend's address, but in vain to hear him actually address you with respect to the section of the FIC Act that was invoked here to provide the certificate that was used in the minister's application.
Well, the evidence says that a decision had to be made as to whom this confidential information is given.
That's correct, my lady, and I don't want to get into semantic gymnastics by saying that, you know, there was a choice made to provide a certificate, but that it doesn't amount to a decision that is administrative action and therefore reviewable under either PAJA or legality. Let's use the same word, let's use decision, although I would say that what occurred here was a choice to provide the certificate, and every day throughout administrative bodies in the land, choices are made. We can even call them decisions. But it doesn't mean that they are a decision for purposes of either Rule 53 or for PAJA or for the application of the principle of legality. Because in fact, my lady, and with your lady's leave, I think the easiest way to do this would be with reference to the three documents that are relevant here. They are attached in the main application, FA1, 2, and 3. It's the request from the minister to the FIC, the response from the FIC to the minister, and the certificate itself. Perhaps it would be useful to consider these documents during the course of my argument. Because, my lady, perhaps I should step back and start with what is at stake here for my clients.
Melanie, I've got
This
some.
copy is better.
I've got
than
some
the one
more.
in the file.
I've got some more legible copies. I picked that up.
Yes, did you also have trouble?
Yes, and I asked for legible copies. And they are here. They just too late to get into the file. Sorry.
Really FA1 that's
Wait, 1, 2, and 3.
Let's start with FA1. If it's unlegible, then it's the routine. Thank you, Mr. Higgins.
I'm indebted to my learned friend. Milady, if we take a step back here and understand the context of this application, the main review application, as well as this interlocutory, and if we understand that what this engages is the legislative framework for how the FIC receives reports of suspicious and unusual transactions from those parties that are obliged to make those reports to the FIC, how the FIC is then under incredibly strict legislative obligations to maintain the privacy and confidentiality integrity of that information, and then how, once it has conducted some analysis and investigation, it provides access to the reported information in very circumscribed set of circumstances. But what has happened here is that for the purposes of legal proceedings brought by the then Minister of Finance, a request was made to the FIC, and that is the document that is FA1 of the main application. There, Minister Gordhan, as he then was, sets out that he has been subject to several entreaties from the Oak Bay Group and the Gupta family and their associates to assist him with the decisions by the big four banks to terminate their banking relationships. He then refers in paragraph 9 of his letter to Mr. Hawa, who was then Oak Bay's CEO, reading out a letter from one of the banks explaining the reasons for closing the accounts on carte blanche, and gave, amongst the reasons why these bank accounts were closed, the fact that in terms of the FIC Act, the bank felt that it could no longer continue in its bank-customer relationship with the Gupta family and the Oak Bay entities. Minister Gordhan then goes on to explain the need for the integrity of South Africa's financial system to combat money laundering and the like, particularly heightened post the global financial crisis. And then he says, and these are the critical paragraphs, from paragraph 13 to 16. He says, I would like to be advised whether or not the banks have indeed reported to the FIC, as indicated in the statement made by Mr. Hawa on carte blanche, or whether no reports have been made. And my lady, if I pause there and just provide you with a record reference, I don't need to take you to the page. It's paginated page 33, paragraph 21 of the interlocutory papers. That is the answering affidavit from the first respondent, where he says that if the answer to the inquiry about whether there were STRs was that there were no STRs, he would have similarly provided the affidavit for the assistance of the court in Minister Gordhan's application. So whether the answer was yes, and here's the list, or no, I have no STRs, he would have responded using the Section 39 certificate mechanism. The minister then explains in paragraph 14 that he's considering a court ruling where he would seek two declarators. The first was whether the Minister of Finance, the Governor of SARB, or the Registrar of Banks could intervene with respect to the closure of the accounts by the banks, and whether there is in fact a basis for the termination. So at the time that Director Michel is given this request, he is advised there are two declarators that will be launched by the minister. It should just be noted that in the end, only the first declarator was sought. But at the time that the request was made, it was a dual declarator application. The minister then notes that on carte blanche, at least one of the reasons given for why the banks had closed the accounts was on the basis of reporting that had been done under the FIC legislation. Minister Gordhan then says at paragraph 16, in view of the above, I request you, pursuant to your powers aforementioned, read together with 29(4)(a) and (c), to inform me at your earliest convenience whether any reports have been received, over what period, in respect of what entities, in what respective amounts, and then says it's not necessary for you to give me any further information. Now, you would have listened to my learned friend's address closely, and you would not have heard any reference being made to section 29, which is the section in terms of which the certificate was issued. He referred to section 39, which is the certificate mechanism, and he referred to section 40, which is the access to the information reported. And he made his argument saying there are a very circumscribed set of... And 29(4) is what the minister's request was framed in terms of. And that, so section 29, first of all, if we just understand what that section is doing, it's the section that places an obligation to you by your ladyship's brother Fabricius, where he looked at the question of the Bank of Baroda accounts being closed, the last domestic bank accounts held by the Guptas and the Oak Bay Group. In that judgment, he notes that in the period from the middle of last year to the middle of this year, an additional 45 suspicious transactions report were filed in terms of, and they disclosed that in that application in terms of subsection 3. So the Bank of Baroda made 45 additional STRs to the FIC. And your ladyship, I have a copy of those papers, including the annexure that lists them, and you'll observe that they are all about, the party reported is the applicant here. But
the judgment's on Saturday.
it is indeed, my lady. I have a copy of the judgment if it would assist the court. Passages sorry, I'm not in the right. Paragraph in what's numbered as paragraph 1.15, you there see that the Reserve Bank conducted inspections and imposed a penalty of 11 million rand for non-compliance with obligations, including under the FIC. And then we see that the additional 45 STRs have been submitted, including 36 about to the FIC.
But the FIC gave us information in this court case before
No, my lady, the 45 STRs here are in addition to the 72 that we know about.
Who was that information given? To whom was it disclosed, the 45 additional?
The 45 additional transactions were disclosed by the Bank of Baroda in terms of 29.3 to the court in the Bank of Baroda decision. And my lady, I have a copy of that annexure that has the list, if it would be of assistance. I have a full set of the papers. Sure. My lady, the point is that then so in terms of section 29.3, the bank, as the person who made the report, could disclose the information for purposes of legal proceedings, which is what the Bank of Baroda does to your ladyship's brother Fabricius. What happens here, however, is that in terms of 29.4a and c, the minister requests Director Michel to make the certificate that he makes. So 4a is where it's required within the scope of that person's powers and duties in terms of any legislation. And then C is for the purposes of legal proceedings, including any proceedings before a judge in chambers. So that is the request that we see in FA1. If we then turn to FA2, which is the response from the director of the FIC to the minister, my lady, you'll see in the second large paragraph that Director Michel recounts how the disclosure of information is strictly governed by Section 40. By virtue of those provisions, the Centre is only allowed to disclose information in very limited circumstances to a limited group of potential recipients. He then says that the FIC Act in Section 29.4c provides for an exception to these controls where such information is to be used for the purpose of legal proceedings. The mechanism provided for in the FIC Act, where the information is to be tendered in evidence in legal proceedings, is by means of the certificate issued under Section 39. He then says, given that your letter indicates your intention to approach a court for a definitive ruling on certain questions of law, and by virtue of my powers under the FIC Act, I have decided to issue a certificate under 39 relating to possible reports that may be made in relation to the entities. I emphasize that it's only for the purposes of introducing evidence in legal proceedings, will only confirm or refute receipt of reports, and the certificate will not disclose any information. 3 days later, the certificate itself is provided to the minister. That is FA3, and if your ladyship turns to the bottom of paginated page 49, there Director Michel on oath explains at paragraph 9 that by virtue of the powers vested in me as the director of the Centre under Section 39, subject to 38.3 in respect of protecting the identity of the reporter, I hereby confirm that the information set out below was reported in terms of Section 29. My lady, as we've made clear in our answering affidavit in the main application, as well as in our opposition to this application and in our heads of argument, those are the only documents that exist that relate to the choice by Director Michel to provide the certificate to the minister. So to the extent, my learned...
As I understand the argument, it's that choice to give the information, the reason for that choice to give the information.
But
or is it simply a clerical task?
my lady,
I've
also...
got these 72 complaints or reporting, suspect reporting, and I'm simply handing them on to the minister of this case. Now, in that, is there not a decision?
My lady, with respect...
As opposed to Mr. Joe Allman.
My lady, with respect, not a decision that is cognizable as administrative action or under the principle of legality. So yes, as a matter of fact, a decision, a choice is made to respond to the minister in the way that the FIC responded. Of course, there's a choice made as to how Mr. Michel will deal with the minister's request. But that is not a decision for purposes of administrative action or legality, because that is a defined term. It's a defined universe. We know what a decision means with respect to administrative action, because PAJA, for starters, tells us what a decision is. My lady, I don't need to detain you because it is in our heads, but it's the list of things, and the only one that could possibly be relevant is where it says that a decision includes the giving, suspending, revoking, or refusing to give a certificate, direction, approval, consent, or permission. The fact that the word certificate appears there, again, is not, there's no mechanistic, formalistic answer to this characterization question. And your ladyship will no doubt have seen my learned friend's reliance on the decision Sokela authored by His Lordship, Mr. Justice Wallace, when he was in the KZN division, where at paragraphs 60 through 61, it is explained, and this has been endorsed by the Constitutional Court in paragraph 34 of its decision in the Minister of Defence case against Mutau, that what is required of a court is to look at whether the particular exercise of public power or performance of a public consideration is properly to be characterized or classified as administrative action. The task is mandated by the provisions of the Constitution itself. It doesn't mean that, I can ignore that, but the present situation is that the Constitution draws a simple distinction between acts that constitute administrative action and acts that do not. And the courts must draw the distinction or essay that process of constitutional classification. And this is the critical sentence for today's purposes. The court is required to make a positive decision in each case whether a particular exercise of public power or performance of a public function is of an administrative character. Then continues to say that this determination doesn't just mean that you classify things by default. It requires a positive finding that particular conduct is administrative action in order for the power of judicial review under PAJA to be engaged. Then goes on to say that this is not a mechanical exercise where the court merely asks itself whether a public power is being exercised or a public function is being performed, and then considers whether it falls into any of the PAJA exceptions. Rather, it requires a detailed analysis be undertaken of the nature of the public power or public function in question to determine its true character. This serves in turn to demonstrate that the exceptions in the definition are not a closed list, nor that cases falling outside of them shouldn't be looked at, and that they wouldn't automatically then constitute administrative action. Let me skip ahead. There's accordingly no mechanical process by which to determine whether a particular exercise of public power or performance of a public function will constitute administrative action. That will have to be determined in each instant by a close analysis of the nature of the power or function and its source or purpose. Requires, again, that firstly, it's required to understand and characterize the nature of the power that is said to be at issue or that is said to be exercised. And it still requires that power somehow affect rights. We know that PAJA requires adverse external legal effect, somehow affecting the rights of parties. The same is true of legality. Legality may be a moral case law on it, but it is not anything in terms of a piece of legislation is reviewable under the principle of legality. If we look at, and my lady, these are in our heads at page 20 and following, if we look at the case law about the principle of legality and its application here in this characterization process, you'll see that it requires things like good faith exercise of a public power, that the power not be misconstrued, that it be exercised rationally, not arbitrarily and fairly. There are very similar types of requirements to those that PAJA demands of administrative action. And we would submit that under either classification, the decision to issue the certificate here does not amount to a reviewable decision under either universe of potential review.
When does it amount to a review decision?
It would amount to...
After the investigation?
Lady, I think if we look at the scheme here, the legislative scheme to detect, investigate, and then potentially have accountability through law enforcement for money laundering. The scheme here sets up an obligation on those with information to report to the FIC. And again, I don't want to be misunderstood to be saying that this is necessarily administrative action, but potentially there's a decision by the bank when it forms its subjective suspicion that this is a suspicious or unusual transaction because it entails money laundering, proceeds of crime, whatever it is. Potentially that is a decision that could affect have adverse external legal effect, may affect the rights of parties. Potentially, that could be administrative action. Of course, my learned friends don't pursue the banks for their reports because the FIC Act says that if in good faith you form that subjective suspicion, you cannot be held liable. So that's why we know they haven't pursued that piece of litigation yet. But potentially, if we were in the classification of powers and functions, potentially when banks report, that may be a decision that has some external legal effect. The information is then passively received by the FIC, analyzed, put together with other pieces of information, other reports potentially. Potentially they use their powers of investigation to get additional information. And at the end of that process, they may then decide that under Section 40 that they want to provide access to information that they hold. And then we see in terms of Section 40 when that can happen. And it'll happen to investigating authorities or intelligence services, the SARS, etc., where the centre reasonably believes the information is required to investigate suspected unlawful activity, a similar companion body outside of the Republic, or an accountable institution or reporting institution that may need to understand, may need to use that information in some way. But even in that instance, it's not the FIC that's determining any external rights of any party. So even at the point where the FIC takes all of the information that's been reported to it, the 72 suspicious transactions that we know of, the extra 45 that we've updated the public record with to date, if you combine all of that, the FIC puts that together and then says to potentially a law enforcement agency that will try to hold parties accountable and liable and criminally liable, hopefully one day before one of your brothers or sisters cloaked in red, that there is something here, that there is potential unlawful activity, suspected unlawful activity. But the FIC is not determining any of these things. The FIC doesn't determine that you should be prosecuted for money laundering. The FIC receives information passively, analyzes it, puts it together with other information that it has in its possession, and provides a report to law enforcement saying, we think this information may be required to investigate suspected unlawful activity. What the Hawks, the Reserve Bank, the Revenue Service, the NPA then decide to do, that may well have adverse external legal effect on rights of parties. But what the FIC is doing as it conducts its work, none of that is administrative action. And nor should it be if you think of the important role that it plays in collecting information, sifting it, and then ensuring that those that seek to engage in corruption, money laundering, tax evasion, and the like are ultimately held accountable by the appropriate law enforcement authority.
So then, if it's not administrative action, BEDA and CompuTicket won't apply?
My lady, our submission is that they don't apply. CompuTicket, as your ladyship knows from your other role in the Competition Appeal Court, CompuTicket was about the referral of a complaint to the tribunal for determination. That is akin to the NPA or the Hawks taking the decision to bring a prosecution that may rely on information it ultimately sourced from the FIC. But it's not an FIC decision that's being taken. So there's no analogy here with CompuTicket. CompuTicket is clearly about the decision to refer a complaint to the tribunal, which has some adverse effect, adverse external legal effect, and the SCA looked at it and said, for purposes of that process, you have entitlements to the record as they described. So we can repeat with as much emphasis, duplication, and insistence that Rule 53 applies and Rule 53 says provide record and reasons, but Rule 53 only applies if you've got a decision that is administrative action or that is reviewable under the principle of legality. We are simply not in the BEDA CompuTicket world. My lady, let me deal with the other contention for BEDA, which is the notion that, what's happening here is piecemeal litigation. And let me suggest this. To require the main application to stall so that we can have this interlocutory is piecemeal litigation. What was put in the answering affidavit in the main application raises the point of law that this is not administrative action and is not reviewable, raises a point of law about joinder, and deals with what happened here in terms of the 3 documents, which is all that exist. If to then say without reasons, they can say that in their reply. I'm fully aware of the rule that says don't make out your case in reply, but given that it would essentially be a slight extension of what we already see in their founding papers in the main application, the notion that there needs to be a supplementary founding affidavit in these circumstances, as opposed to them filing a reply so we can determine the main application, that would be our submission on piecemeal litigation. That to recast things as a letter or a notice and then have 3 further steps, a supplementary founding, another answer which would replicate this answer, and then a reply. That truly seems to prolong the resolution of the main application. So, my lady, in sum, we say there is no basis here for the court to determine that this is reviewable administrative action, because the choice to issue the certificate has none of the features of administrative action or of a public power being exercised in a way that would implicate legality. And my lady, you would have seen that in any event, we've demonstrated compliance with the principle of legality to the extent it requires there to be a provision of legislation in terms of which a certificate is issued. We've pointed you to section 29, 39, and 40, and how they operate to provide a mechanism for providing evidence to the court that heard Minister Gordon's application to confirm a simple fact that there had been these reports received that related to the parties in that case. So for all of the reasons that are listed at page 9, paragraph 16 of our heads, we say there is simply no decision here. Milady, again, the high watermark of what I now understand the applicant's case to be is that there's a decision to give access in terms of section 40 is what my learned friend said. For all of the reasons we've already explained, there is no section 40 access to information being provided here. That is where the contents of what is reported parties, including the applicants. Because what we must understand is what is reported in an STR. So yes, what you see is what you see in the certificate. It's given a unique identifying number, it's submitted on a certain date, it's required to identify the party that is being reported, and then it assigns a value to the transaction that is reported, other than in the instances where we see multiple transactions listed, which means that the general activity on the account raised suspicion and appeared unusual. But all of the detail of what would be in a suspicious transaction report has not been disclosed and will not be disclosed, not to the minister, not to a party who is the subject of the report, to nobody except investigating and law enforcement authorities with national mandates to pursue unlawful activity. So the reasons why a transaction is reported, that subjective suspicion that the bank developed when it decided it was obliged to report to the FIC, that is the information that is governed by Section 40, and it is not provided here. So there has been, so with respect to the first decision, as my learned friend described it, there has been no decision to grant access in terms of Section 40. That is simply an incorrect proposition. To the extent there has been a decision or a choice to provide the certificate in terms of 29(4)(c), read with Section 39, for all of the reasons we've explained, those are not reviewable administrative action. And one can understand the rationale for those two provisions being adopted by the legislature from a policy perspective. You want the fact of the report, which is what 29.4 is all about. It says that no person who knows or suspects that a report has been or is to be made can disclose the knowledge or suspicion or any information that's the contents of the report to anyone, including the person in respect of whom the report is made, other than, for relevant purposes here, for the purposes of legal proceedings. So it's an absolute bar to disclosing the fact of the report, and you can understand why. You don't want parties getting pre-discovery before they get to see their docket and make representations in a criminal case. You don't want them getting to see what their banks are starting to piece together about how they conduct their financial affairs and the flows of funds through a set of related companies and associated persons. It's important that the FIC be given, my learned friend spoke about in the dark and in the light. It's important that the FIC be given the protection to conduct its work in the appropriate circumstances with a blanket protection of the information that people share with it. Then one can understand in terms of Section 39 why it would be this affidavit certificate mechanism. Because what it's doing is confirming the receipt of the report in terms of Section 29, and it's doing it in a manner that is admissible without the need for direct or oral evidence. So it is purely so that on production of that certificate, the affidavit here, the court that was considering the minister's application would have the confirmation of the fact that 72 STRs were received by the FIC about the Oak Bay Group and the Guptas, rather than an FIC representative having to come, take the stand, and provide that direct oral evidence. So it is true that there was a choice made to use the affidavit of Section 39 to provide that confirmation to the minister's court, or the court that sat in the minister's application. But it was done for the assistance of that court and in the most effective and efficient, through the most effective and efficient mechanism. So the choice of Section 39 doesn't become a reviewable decision for administrative action purposes. We can test those submissions, and with respect I would submit that they must be correct, because if it were to be administrative action when you were choosing to use the Section 39 certificate, then how would courts ever gain the assistance of the FIC in confirming something that was relevant to its proceedings without that mechanism? It's something that, like when, and my learned friends have not responded to the submission at all, like when the South African Revenue Service provides a tax clearance certificate that confirms that a taxpayer's affairs are either in order or not in order, merely records that fact. When the chair of the Competition Tribunal certifies that there's been a finding of prohibited practice for the sake of a Section 65 follow-on damages action, it merely certifies a fact. Nothing more. It's not determining any rights. It's not standing in for SARS, exercising discretions and collating information and understanding what it's being told and then taking a view on something. That may be a decision that would be administrative action. It's merely recording a fact.
It's the decision to provide the information to the minister. So that's not a decision.
No, my lady, because
You see, I understand your submission on the certification of the fact. You're saying there's no application of Section 40.
there's absolutely
For the purposes of the litigation, but
And my lady, Mr. Joe Ordinary, if he comes under section 29(4) and says, for the purposes of legal proceedings, and I tell you what those are and what they're going to entail and why it's relevant that you confirm the receipt of an STR or not, then there could be Mr. Joe Ordinary getting a certificate similarly under 29(4). Same as when Joe Ordinary goes to SARS and says, can I get a tax clearance certificate about something that I need for a lawsuit that I'm running? So it's a clerical task. A request comes in. If it's a request that falls within 29, then I give a certificate. Yes, I'm deciding that, and I'm evaluating that request, but that doesn't make it administrative action. So if we go back and look at what is required for if we go back and look at what the applicant themselves said is required.
Paragraph 30, page.
No, it's not mine. Page 46, paragraph 12 of the papers. There it is set out what the steps are in a decision-making process that may be cognizable as administrative action. There needs to be a request in the capacity of the authority to exercise a power in relation to a set of facts that apply to the person making the request, that the relevant information must be presented, it must somehow be gone through to evaluate, and then they say there would be some evaluative process where you would consider all the information, identify components that are relevant, identify what's irrelevant, assign value judgments, degrees of significance, all of these things to each component of information. None of this is what's happening here. What's happening here is I ask you for a certificate to confirm if you've got any STRs, and I give it to you. I'm not getting information about some particular myself of the certificate. That's not happening. What's happening is I'm saying I need for legal proceedings confirmation using your certificate of the fact of receipt of STRs. That's all that's happening. I'm not saying I'd like to apply for a license to do something. So if we look at the surrounding examples that are given in the definition of a decision in Haja, giving, suspending, revoking, or refusing a certificate, direction, approval, consent, or permission. You can conceive of a world where someone is putting forward facts and saying, I would like you to give a certificate so that I can go and do something, and I need to persuade you in some way. There's no persuasion here. There's no discretion that I must exercise on the basis of what you tell me and how I evaluate it, so that I'm persuaded to give you some right that you can go out into the world and enforce. That's not what's happening here. What's happening here is that I'm being asked to issue the clerical certificate confirming a fact. I would issue it if there were no STRs. I will issue it to run over 4 pages when there are that many STRs. That's all I'm doing. My lady, I'm instructed that were Joe Public to come and request a certificate, it would, like the minister, have to satisfy both 29(4)A and C. So it would have to fall within the scope of the person's powers and duties and be for the purposes of legal proceedings. You'll recall that in Director Michel's response, which is FA2, he explained that as he understood the case that the minister was bringing, it relates to the duties, powers, and functions of the FIC and the ministry with respect to banks. And of course, the FIC is part of that oversight function in the banks. So he says that given that you are intending to approach the court for the definitive ruling on questions of law, and by virtue of my powers, I'm giving you the certificate. So if there were, let's assume that Joe Public somehow has some duty under a piece of legislation and is bringing a proceeding so that he can somehow vindicate some rights or duties that he has, then perhaps the certificate would similarly be issued. But it simply fails the test that the applicants themselves have set, which says there must be some evaluation, some discretion that I'm needing to be persuaded to exercise in your favor. That is simply not what is happening here. Those are our submissions.
My lady, I nearly echo my learned friend's last session of argument. She says, all that the director did was say, by virtue of my powers, I'm giving you a certificate. But she glossed over what he actually said. He said, given that your letter indicates your intention to approach a court for a definitive ruling on certain questions of law, and by virtue of my powers under the FIC Act, I have decided. In other words, he had a choice. According to himself, he had a choice to issue the certificate or not to issue the certificate. And he decided. It is that decision which we want to take on review. My learned friend, in response to your ladyship's question, so Joe Ordinary could come and ask for it. Well, yes, his request would be considered, said my learned friend. Considered. In other words, it would be decided that he could, or it would be decided that he couldn't get access to the information. That's a decision. And it's that decision, in this context, that we wish to have set aside on review. My learned friend has not answered the Competition Commission question. They're not, the principles transferable from BEDA and from the Competition Commission are not affected by the underlying facts of that case. If one has a look at section 29(3) and 4, 29(3), no person who made or must make a report in terms of that section may disclose that fact or any information regarding the contents. We know there's more to it. So that's the bank that reports to the FIC may not tell anyone that it made such a report. And then, no person who knows or suspects that a person, that a report has been made or is to be made may disclose that knowledge or suspicion or any information. That's not the FIC. That's someone in the bank who knows about it or who heard about it. It's not the bank. So, no, because not the bank, it's not the FIC. The FIC can disclose in terms of section 40, and the minister is not one of those. This covers persons reporting or who know about reports, not the FIC. So to justify a decision, see FA2 page 45, on the basis of section 29(4), as apparently might be the case, that would be classically reviewable. And to make it with no reasons would also be classically reviewable. So there is, in my learned friends, no argument that there's no decision that falls to be reviewed. And if you look at our heads, ma'am, at page 11, paragraph 30, where we take from Gray's Marine Hout Bay Hotel case quoted there, and one of the various ways in which the test for an administrative decision has been phrased is, and it's at the bottom of page 11, a decision of an If you look at section 45, capital C of the FIC Act, there's a heading, administrative sanctions. The centre or supervisory body may impose an administrative sanction on an accountable institution. And it goes on to list various of the aspects of administrative function performed by the FIC. That it is a body making administrative decisions is evident from the entirety of the Act. But I'll make that point in passing. The Gray's Marine case says the definition of administrative action can be broken up into 7 component parts: a decision of administrative nature, Now, obviously there, it is a decision made by the FIC who effect an administrative function, and the decision is to issue a certificate or not. In my words of my learned friend, Joe Ordinary can come and ask, and it will be considered by an organ of state or a natural juristic person. This is an organ of state, exercising public power or performing a public function, clearly does that, in terms of any legislation under the FIC Act that adversely affects rights. The applicant's rights were affected in that the fact that STR, suspicious transaction reports, were made is revealed. Not necessarily the contents, the fact that there have been. Imagine how, I don't want to pick on anyone here, imagine how I'd feel. If, yeah, I nearly did. I went for your registrar, but he looked so innocent. It's in the newspaper, or it's in some proceedings. The FIC has issued a statement that there are 2 STRs out there about Mike Helens. Of course, it adversely affects rights. It has a direct external legal effect. The world knows, and the court was asked to take into account. It refused to do that, by the way. I found the whole thing to be irrelevant and struck it out. But it was sought to be relied on. That does not fall within the listed exclusions, and it doesn't fall in a listed exclusion. My learned friend cannot escape, and the respondent really cannot escape, the choice of words. I have decided to issue a certificate. The minister, when he writes, he asks for a decision to be made. He asks for this to be done. He doesn't say, push the automatic button on your computer. He says, I ask you to do this. And the director says, I've decided to do it. It's that decision. And we need the record of that decision. My learned friend says now that they don't need to file anything more. But I've referred you to page 200, paragraph 4 of the papers, where they don't say there's nothing more. They don't say there are no reasons. They say that which is quoted in paragraph, which I quoted from paragraph 4. Since the first and second respondents ask this court to determine the raised in this affidavit first piecemeal decision, there is no record to file at this time. That is the CompuTicket beta death knell to this argument. So there is a decision. They wish you to first decide whether there was a decision, whether this is administrative action, and then at some later time, not this time, they'll file the record of the decision and the reasons. Of course, in their heads they say there's nothing more and there are no reasons, because notionally this computer was pushed and it spat out this information. Well, we know it didn't spit out the information, because the information must be who reported it in respect of what specific transaction, in what amount, and far more detail. So a decision was made, yes, I will respond, and yes, I will put in the certificate the information of this limited nature. So there is clearly a decision exercised by a public body satisfying all of the tests. Milady, I have asked my team to prepare a note on this one. It really summarizes the argument that I've already made. It's not new heads of argument, but without oversharing, I had difficulty understanding what it is that the respondent said. So I asked that what the respondent says be encapsulated and then it be commented on, and it is a note on that. And I'd happily let my learned friend have a copy. It's nothing new. And I will give your ladyship a copy. But really, the heart of it is, insofar as they say that no information was disclosed, it was just the production of a certificate, they say that the issue of the certificate is not governed by Section 40 of the FIC Act because it doesn't disclose information held by the FIC, and that's in their heads of argument. There's a footnote referring to it. We say that's not correct because the fact that an STR has been submitted, as well as the content of the STR, are confidential under the FIC Act. Section 40 governs the disclosure of both. And it must be so because Section 40 governs the disclosure of any confidential information by the FIC, and there's no support in its terms for distinguishing between the disclosure of the fact of an STR and its content. Because the moment you say, Helen's just got 5 STRs out against him, that's as good as giving the content. There's no other provision in the FIC Act that empowers the FIC to disclose the mere existence of an STR. Section 29(4) is about the disclosure and a person who knows about a disclosure having been made, not the FIC who sits there as the receiver of all that information. So they are entirely wrong if when they say our reasons were, when they file a record of decision and reasons, they would be wrong. And I warn them now that they're wrong. If they say they relied on Section 29(4) A or C, because that would be unsustainable. And then the argument is that there's no right or interest that is affected. And we say, of course there is. The disclosure of the fact of the STRs invades the constitutional right to privacy, contractual right to confidentiality over their banking affairs, the statutory right to confidentiality of STR reports. All of those rights were impinged, and that's sufficient an incursion to pass the test that we have enunciated, or that we have set out in the Gray's Marine, or enunciated in the Gray's Marine. So, my lady, it's just a note. There's nothing new, but it helps look at the argument of the respondent and see why it's wrong. So, in summary, and I think your lady has the length, breadth, and depth of the argument, there is no gainsaying the words of the director himself. I have decided to issue a certificate. There's no gainsaying the argument that says, well, if Joe Ordinary applies, then there'll be a decision whether to grant it, whether not to grant it. The words of the director himself shows that he sat back in his administrative chair. He received the request for a decision, for a certificate, or for the fact that STRs were made, and said to himself, yea or nay? Do I have the power? Do I not have the power? My lady, my learned friend asks you, and the respondents ask you, let me be fair to her, they ask you to write a judgment that says, Section 29(4) A and C mean, if, and notwithstanding all of the confidentiality contained in the Financial Intelligence Centre Act, if anyone, be it Joe Ordinary or the Minister of Finance, decides that for purpose of litigation, legal proceedings, and requiring evidence for those legal proceedings, approaches the director, he must give a certificate. You would open the doors of chaos to the confidentiality enshrined in the Financial Intelligence Centre Act. It is the mechanism by which you trace cash transactions, money laundering, etc., and properly controlled, with being revealed only to the National Prosecuting Authority in the appropriate investigation, and behind closed doors, legitimately so, crime is pursued. That is the fact. What the judgment would be that is asked of your ladyship is this. Read Section 29(4) A and C, weep, because anybody that approaches the FIC can get such a certificate if they just say they're going to litigate. And there's no decision. Well, put it this way. Anyone can ask the director for such a certificate. And if that is the question, and if I overstated it earlier, then I'll make my point better. Because then the minister can, the director can decide whether to or whether not to. And that's an administrative decision. So we need the record and the reasons so we can pursue it. The argument is lame, if I can say that in the softest way, that says we are calling for piecemeal legislation by insisting on sticking to the rules of Rule 53. Not sticking to the rules of Rule 53 means that we're forced to compel, like in all other matters when an irregular step is taken, you have to bring the party back in line, comply with the rules, and then we'll carry on. I had a matter on the motion roll this week. It was set down for Thursday the 12th. Now, Thursday is not the 12th. It's, what was it? Now, set down for Tuesday the 12th. That's right. So it's an irregular step. You can't set down something for a day which is not the same date. Now, what are they saying to me? I'm doing piecemeal litigation. I don't even know what date the matter is set down for. They set it down for Thursday with the date of Tuesday. I'm not making a lame point. I'm saying the rules by which we approach your ladyship, for your ladyship to decide matters, this is a rule 53. Review I don't have to give reasons, and therefore you can't bring a review, and therefore you can't use the rule. Clearly you can. Clearly a decision was made, and we would ask for an order in terms of the notice of motion to complete the documents on which the decision was made and the reasons, and then secondly, in the slightly watered down fashion that I've already indicated, strictly speaking, the answering affidavit should be set aside as not there because they have answered too soon. But to the extent it might be form over substance, your ladyship's judgment should show that we're entitled to file, in terms of the rule, a supplementary founding, and to the extent that there's been premature answering, that that answer can be supplemented in response to the way that we supplement our founding papers. And we would ask for that order, including the costs of not 4 but 2 counts.
My lady, I've not had the opportunity to consider the note or to take instructions on it. If it is as my learned friend claims and it merely recites what we've already heard, then we will notify your ladyship that we don't need to submit anything. So a bit like Director Michelle, if we do or we don't, if we could have a few days to respond to the note which we hadn't seen previously. And then, my lady, if I can just correct... Thursday. And then, my lady, if I could just correct a factual error made by my learned friend with respect to on his submission about external rights that were affected by the disclosure of STRs. As recorded in the Minister's letter at paragraph 13, it was in fact Mr. Hauer's carte blanche interview that disclosed the FIC looking at their accounts.
Right, thank you. I'm going to